There's a few ways to open up a probate estate in Michigan. Hi, I'm Darren Findling from the Probate Pro. We're going to spend some time discussing the two primary types of probate administrations in which you're beginning and opening up probate. The first we're going to speak of is what we call informal probate administration. Informal is done by the use of an application for informal probate. Now, when you do an application for informal probate, you are required to have certain criteria in place before the court will accept your application for both filing and issue letters of authority. You need the person with the highest order of priority to serve as personal representative to be nominated, or if you don't have the highest person named within the statute or within the will, then everybody above that person in priority will have had to, what we call, renounce, sign a document saying that they agree for you to serve as personal representative. The other way you can open it up informally is by using what we call the notice of intent process, in which you give notice of the opening informally, 14 days go by, and then you can open up and commence the estate through an informal application for probate. Now, one of the downsides of opening up an informal administration is that if there's a will, that will does not get admitted to probate. It is left it's filed with the court, but it's not admitted through a court order, which doesn't put a time bar upon which a challenge to a will can occur. One of the advantages of an informal application for probate is there's no court hearing. There's no matter in front of a judge in which you stand under oath and testify to open up the estate. It's a more informal, as the name is called, process to begin and open up a probate estate. Now, the other way of doing it is through what we call a petition or a formal administration. Formal is the default way of doing it, so that if you don't do it by application, it is expected that you will formally ask the court to open up the estate, nominate or name a personal representative, and ask for the admission of the will, or if there's no will, for the probate to be intestate. Now, a formal administration generally is going to require a court hearing scheduled a few weeks after the filing of the petition, in which you stand in front of a judge and have the proceeding such that you get a letter of authority. Now, another really interesting aspect of the formal versus informal are some of the requirements that occur thereafter. In a formal administration, especially in certain counties, there will be a restriction on that letter of authority prohibiting you often from conveying real estate, selling or conveying real estate without another court order. So it requires another court proceeding. In addition, the formal proceeding will generally or often require a bond to be in place to protect the creditors and the other interested parties within the estate administration from you making a mistake, you, the personal representative, making a mistake or stealing the money. That increases the expense, as well as there are many people that can't qualify for a bond, so it can be awfully frustrating. So the decision on whether to proceed informally or formally is really a strategic decision that you should weigh carefully, because it's not as simple as I just want to save money or I want it to be faster or easier. There are some trade-offs on whether to proceed with an informal administration or a formal administration. Generally, if you walk into the probate court, most of the probate courts are going to default you by sending you through the formal administration and not give you an application for informal probate. Unless you know to ask for it, they're not going to generally hand you that form. Now, these decisions from the beginning of the administration all the way through to the close of the administration are strategic. There are definitely cost-benefit analysis that I haven't even given all of them here that you want to be weighing as you're proceeding through the administration. If you've got more questions on whether to proceed with a formal administration or an informal administration, give us a call at 877-YOUR-FIRM or visit us at theprobatepro.com. We'll guide you along through the probate administration process.